Good morning, everyone. Can everyone hear me okay? Excellent. Welcome to this morning's press conference. Bonjour et bienvenue à toutes et à toutes à notre point de presse ce matin. Parmi nous aujourd'hui, nous avons l'Association canadienne des sociétés Elizabeth Fry du Canada, l'Association canadienne de la société John Howard, l'Association canadienne des libertés civiles, ainsi que le Black Legal Action Center. Pour commencer, nous allons recevoir la directrice générale de l'Association canadienne des sociétés Elizabeth Fry, suivie de plusieurs autres intervenants. So good morning to all. We've got today present the Canadian Association of Elizabeth Fry Societies, the Canadian Civil Liberties Association, the John Howard Society of Canada, the Black Legal Action Center, as well as other members and experts of civil society. We are going to kick off this press conference with opening remarks from Emilie Coyle, the Executive Director of the Canadian Association of Elizabeth Fry Societies. Emilie, the floor is yours.
Thank you very much, and thank you to everyone for joining us today as we are holding this press conference on the first day that the premiers of the territories and provinces meet for their summer gathering in Winnipeg, because, as you all know, our bail system has been hotly debated over the last few months, largely driven by the provincial and territorial premiers' call for more restrictive bail reform. And now, in response, the federal government has tabled Bill C-48. The organizations that are here today are deeply concerned that recent and dangerous discourse on bail reform is pushing law and policy in a direction that will harm rather than protect Canadians by further restricting access to an already onerous bail system, while seemingly ignoring an extensive body of social science research. And this is a crisis that has led far too many people to being held in pretrial detention. So in other words, decades of evidence regarding the bail system and the impact of pretrial detention demonstrates that making getting bail harder does not enhance public safety. And if this is used as a reason for legal reform, it has the potential to cause significant harm to individuals and to the public. We, the organizations and the individuals who are represented here today, we understand the instinct to want to address harm that happens in our communities. We are driven by mandates that respond to this instinct, and with today's press conference, we are hoping to prevent more harm from happening. Our provincial jails are filled with people that have not been able to access justice and are still awaiting trial. The numbers are shocking. More than 70% of people in our overcrowded jails have not had a trial, let alone a conviction. And these are people who have been disadvantaged and often face multiple social barriers. Our criminal legal system relies on the fundamental right to the presumption of innocence, and related to that, the right to reasonable bail. And this is a critical point. My colleagues here today will speak to various aspects of the issues with our bail system and share with you the reality of what it is like to try to get bail in Canada for the thousands of people who are denied bail every year. And I'll pass it over to my colleagues now. Thank you very much.
So next up, we have Shakir Rahim, Director of the Criminal Justice Program at the Canadian Civil Liberties Association. Shakir, the floor is yours.
Good morning, everyone. I will provide an explanation for some of the main topics of our remarks this morning. When someone is charged with a crime, they have the right not to be in prison before their trial. This is known as bail. To receive bail, a judge or justice of the peace must be convinced a person will attend court and not pose a risk to public safety. A person may need to follow rules, like having to live with someone in the community or not contact certain people. Why is bail important? Because being charged with a crime is an accusation, not proof. Proving someone committed a crime can only happen in a trial or if a person pleads guilty. which is why every person in Canada is presumed innocent after a criminal charge. In Canada, 50% of criminal cases do not result in a person ultimately being found guilty of what they are charged with. Without bail, many innocent people would be in prison in what is called pre-trial detention for a very long time. Because a person charged is presumed innocent, it is the government that must usually prove why they should stay in prison before a trial. Bill C-48 changes that by introducing what is called a reverse onus for some charges. A reverse onus is where the person charged has to prove they should not be in prison before they have their day in court. This flips the presumption of innocence on its head. Someone has been accused of something, has not been found guilty of it, but they have to prove why they should maintain their freedom. What are some of the reverse onuses that Bill C-48 introduces? First, a reverse onus for someone with a prior discharge related to intimate partner violence. A discharge is when a person is found guilty but does not receive a criminal record. It is only available when a judge concludes a person is of good character and it is in the public interest to discharge them. Bill C-48 also introduces reverse onuses for certain firearm-related offenses. These include licensing offenses, like not completing registration paperwork on time or storing a firearm in a different location than from licensing papers. As the Supreme Court has said, licensing offenses pose little or no danger to the public. That concludes my portion of these remarks. Thank you.
Thank you, Shakir. We will now go to Catherine Latimer, Executive Director of the John Howard Society of Canada.
Thank you, Alex, and thank you very much for wanting to hear the position of the John Howard Society. We believe that the amendments to the bail provisions that premiers are calling for will not address the massive dysfunction of our bail system. The proportion of Canadian prisoners held behind bars without having been convicted and sentenced for a crime is significantly higher than in most other developed countries. So in England, the percentage of prisoners kept in jail prior to any finding of guilt or sentencing is 11%. In the United States, it's 22%. In Canada, it's a massive 37%, so roughly 3 times higher than most other developed countries. This high percentage leads International Monitoring Organization and others to question whether the presumption of innocence and the right to reasonable bail are being respected in Canada. It is not surprising that in 2018, the United Nations Committee Against Torture urged Canada to, quote, ensure in law and practice that pretrial detention is not excessively applied or prolonged, unquote. In fact, the situation is getting worse. Provinces, not the federal government's legislative authority, but provinces have the responsibility of police. They are responsible for programs which could support people in the community and keep us safe rather than putting them in jail. They're responsible for the speed with which the pretrial detention provisions are applied, and they're responsible for many other opportunities to make the system much more effective and fair. We urge the premiers to acknowledge their responsibility and agree to collect evidence needed for a fundamental review of the pretrial detention and release practices. The whole system needs to be overhauled. Thank you very much.
Thank you, Catherine. We're now going to go to Meaghan Chambers, the Executive Director of the Elizabeth Fry Society of Simcoe Muskoka and Vice President of the Council of Elizabeth Fry Societies of Ontario. Meaghan, the floor is yours.
Thank you, Alex. Good morning, everyone. Today I'll be speaking on conditions of confinement in jails across the province of Ontario. So the Council of Elizabeth Fry Societies of Ontario is a provincial network with a mandate of reviewing, inspecting, and reporting conditions of confinement in correctional institutions that incarcerate women and gender diverse people in the province of Ontario. Our most recent visits this year into the institutions have brought to light declining, shocking, and deplorable conditions worse than what we've previously witnessed and reported. Some of the consistent issues across the province that we're seeing is regular overcrowding, the use of segregation, where women are locked in cells for days and weeks at a time without access to showers or changes of clean clothes, frequent lockdowns due to staff shortages. There are unaddressed facility maintenance issues like mold in bathrooms and cells, and plumbing issues so bad that we've had women report to us having to drink out of their toilets of their cells for not having access to clean water. Despite general belief, there's also little to no access to mental health care, programming, cultural supports, discharge planning, or social workers, and what little is available in the institutions is often interrupted by frequent lockdowns and staff shortages. It's important to note that in Ontario, 79% of those incarcerated in provincial institutions are being held on pretrial detention and have not been convicted of any crime. Ontario jails are also disproportionately filled with racialized, marginalized individuals, in particular Black and Indigenous individuals, those experiencing poverty, homelessness, and those who are criminalized for mental health issues and substance use. People who enter incarceration are forced to surrender almost all control and agency over their well-being. There's an assumption that those who assume that control will. Yet across Ontario and over the past several years, deaths in custody have risen steadily. For example, in 2014, 19 people died while in custody in Ontario facilities, and in 2001, that number has risen to 46. There's inquest after inquest into the deaths across the province, where jurors are spending hours aching over recommendations that are not binding and are not implemented to prevent future deaths. That concludes my comments. Thank you.
Thank you, Meaghan. We will now go to Deniqua Edwards, the legal director of the Black Legal Action Center. Deniqua, the floor is yours.
Thank you. Good morning, everyone. The Black Legal Action Center is a not-for-profit corporation set up in 2017. Black's mission is to educate, advocate, and litigate to combat and eradicate individual and systemic anti-Black racism in Ontario. Black provides free legal aid services to low and no income Black people in Ontario who are facing a legal issue directly related to anti-Black racism. Black agrees that a comprehensive strategy to address bail reforms is long overdue. However, Black does not agree that the proposed legislative changes will result in reducing offenses committed by persons while out on bail. The proposed changes are concerning to our communities across Canada for many reasons, as it's well established that at every step of the system, wherever system actors exercise their discretion, they exercise that discretion to the detriment of Black people. It would be challenging, if not impossible, for Black people who frequently do not receive the same benefit under the Charter of being presumed innocent to meet a reverse onus presumption. For example, numerous studies have shown that the police are more likely to stop and search Black people, charge Black people, and use force against, seriously injure, and kill Black people. It has also been documented that members of the bench, judges, and justices of the peace are more likely to hold legally innocent Black people in pretrial detention and impose more release conditions on Black people who are granted bail. Between 2006 and 2015, the proportion of white youth admitted to pretrial detention decreased, while the proportion of Black youth increased. As a result, Black people continue to be subject to mass incarceration. In 2018-2019, Black people accounted for 7.2% of federal offenders, while comprising only 3.5% of Canada's population. A study in 2021 found that nearly 1 out of 15 young Black men in Ontario have experienced jail time, compared to about 1 out of every 70 young white men. Black women were also incarcerated at a much higher rate of 259 per 100,000, while white women were incarcerated at a rate of 96 to 100,000. Once in prison, Black people are more likely to be placed in maximum security and segregation. There are many institutional charges levied against those incarcerated. Force is more likely to be used against those Black inmates, and it is oftentimes security threat designation is misapplied against Black people, thereby limiting their access to programming, treatments, and opportunities for parole. Black considers the social determinants of justice. These are socioeconomic conditions that disproportionately lead to the criminalization of Black and other racialized communities. These are social factors that lead to negative justice outcomes. There are 5 social determinants of justice: income, employment, stable housing, education, and health. We are pleased to hear that ministers will turn their minds to a few of these issues at their meeting. Those who fare poorly by social determinants of justice measures are more likely to have encounters with the police. This creates a vicious cycle. We know that the risk of interaction with the criminal justice system and interaction with the police constrains the ability to improve these social determinants. Once you have a criminal record, it's very difficult, for example, to obtain certain types of employment. Your record follows you everywhere. For these reasons, Black asks that all ministers carefully consider anti-Black racism and its disproportionate impact of the proposed bail reforms on Black people when considering those reforms in Canada. That concludes my portion of this conference. Thank you.
Thank you, Danette. We're now going to go to Rachel Fader, PhD candidate at the University of Ottawa and member of the Canadian Association of Elizabeth Fry Society's Systems Change and Transformative Voice Committee. Rachel.
Thank you, Alex, and good morning, everyone. Even without a reverse onus bail process, it is very difficult for people to get released on bail. When I was arrested in 2011 for a nonviolent offense, I had no prior criminal record. I was enrolled in full-time graduate studies and working part-time. I spent 3 days in custody before I was granted bail, set at over $50,000 with exceedingly strict conditions. Unlike most incarcerated people, I was in a privileged position, being able to collect phone calls to find a surety, which is a person without a criminal record that posts bail and is responsible for ensuring conditions are followed, who was able to come to court during the day to bail me out, supervise my conditions, and had the necessary financial resources. I was released on house arrest, requiring me to always remain inside unless I was with my surety, even to go to the doctor. This meant that I lost my housing, belongings, my job, and I was forced to withdraw from my PhD program. I was not allowed to own a cell phone, required to abstain from alcohol, and report to the police once a week. This was extremely isolating and hard on both me and my family. My trial date was 3 years away, and after 2.5 years, I breached my conditions by leaving home one evening and was subsequently locked up in a maximum security jail for 6 months. We've already heard about some of the horrible conditions in provincial jails, where people inside are subjected to frequent lockdowns, strip searches, violence, overcrowding, horrible food, and lack of health care, among other things. Going to trial from jail adds an extra layer of torture. My trial was 3 months long, which meant I had to travel 1.5 hours each way to court 5 days a week. I was woken up at 5 a.m. and didn't return to the jail until after 8 p.m. so I wasn't able to shower, use the phones, or eat regular meals. My daily routine consisted of being taken down to a holding cell with restraints on my hands and feet, put into an unsafe metal transfer van without seatbelts, windows, cushions, or heat in the winter, then locked into a filthy court cell with nothing to occupy my time. All my meals consisted of a cheese or tuna sandwich. Every night I was strip searched. After 2 weeks of this horrible treatment, I was forced to enter a guilty plea for a crime I was not guilty of because I couldn't imagine surviving another 2.5 months of these torturous conditions. Prison has had long-term negative impacts on my emotional, physical, and mental health, requiring years of healing to overcome the trauma of imprisonment. Thank you.
Thank you, Rachel. We're now going to conclude with Amanda Butler, Assistant Professor at the School of Criminology at Simon Fraser University. Amanda.
Thanks so much, Alex. I appreciate the opportunity to provide some remarks on this topic. Last year, I was commissioned by then BC Attorney General David Eby to investigate the issues of repeat offending alongside former Deputy Vancouver Police Chief Doug Lepage. And what was really consistent in our interviews and consultations was that serious mental health and substance use challenges were noted as contributing factors in many cases of repeat violent offending. Exacerbating these issues is a highly toxic drug supply in Canada, which is killing people and leading to a rise in acquired brain injury from non-fatal overdose. As noted by Meaghan earlier, the health status of Canadians in custody is very poor compared to people who do not experience incarceration. The prevalence of mental health and substance use needs among people who are admitted to correctional centers is continuously increasing in Canada. Over a 9-year period here in BC, a study found that methamphetamine use disorder rose by 359% among people admitted to custody. And the most recent data we have estimates that at least 3/4 of people admitted to prison have either a mental health issue, substance use disorder, or both. We have limited options for diverting people with mental health and substance use needs away from the criminal justice system into appropriate care, and they are disproportionately impacted by short, disruptive sentences in custodial environments where their mental health is likely to only deteriorate. When somebody commits an act of violence while on bail, we understand that this has significant impacts on victims and community members and can lead to a lack of confidence in the justice system. Nonetheless, a myopic focus on bail as the core problem and introducing restrictive bail conditions as a way to address this problem is deeply flawed. The greatest improvements in public safety and public confidence in the system will be achieved by focusing on upstream solutions and interventions that will actually address the root causes of crime, including substance use needs, mental health, poverty, and homelessness. Not only are our remand centers woefully understaffed when it comes to health services, but prisons are by nature not health promoting environments. Remand centers in particular are highly focused on security and have few, if any, programs to address the needs of people who are detained. And criminalizing vulnerable people with mental health and substance use needs embedded within the bail system will only create new and more challenging public safety concerns. Incarceration for short periods of time are not only ineffective at reducing recidivism, but short sentences have been shown to actually be criminogenic in themselves, which means that the highest recidivism rates are actually among people who receive short sentences. The chief executive of a UK charity called Revolving Doors recently described short sentences as nothing but a hideously expensive policy failure. So as emphasized in the report that I wrote with Doug last year, significant investments in poverty reduction, housing affordability, and the continuum of care for mental health and substance use needs holds the most promise to drive down crime. That concludes my remarks. Thanks, Alex.
Thank you, Amanda. We're now going to have some closing remarks offered to us by Emilie Coyle, Executive Director of the Canadian Association of Elizabeth Fry Societies. And from there, we're going to open up the floor to questions from members of the media. If you do have a question, please signal in the chat or raise your hand, as well as identify the news outlet which you represent, and I will unmute your microphone. Emilie?
Thank you, and I will be brief and will welcome questions. So just to conclude, we are all very pleased to see that the focus of the Premier's meetings this summer will be on housing and healthcare, as it is clear to those of us who work with people who are seeking bail, who are in pretrial detention, that the problems with the bail system are not only a reflection of wider problems in the Canadian justice system, but also a lack of investment in community-based supports and services. And as was just mentioned by Dr. Butler, interventions upstream and at the bail stage may also reduce problems in other parts of the system. And so this is more important now than it ever was. As you heard from Meaghan earlier, that people are dying in our provincial jails at a higher rate now than they ever were before. Also, we live in a country that is committed to reconciliation with Indigenous peoples, and yet we still incarcerate huge numbers of Indigenous peoples all over the country. And so we are asking that the premiers of the provinces and the territories join us in advancing an informed public discussion about what is needed to keep us all safe. Band-aid solutions like increasing reverse onus provisions are likely to do more harm than good. Please learn about the conditions in these jails for yourselves and speak to the people who are within them. A comprehensive review of the bail system is needed, and we want to be able to count on your support and investment in this essential action. And I will conclude there. Thank you so much.
Thank you, Emilie. Okay, we're now going to go to our question and answer period. I have Alan Hill.
Hi there, can you hear me?
Yep, loud and clear. Go ahead.
Okay. So it's an interesting sort of time that you bring this topic up. We had another high profile stabbing in Toronto by someone who has been, by a suspect who has been charged with breaching his release conditions. It sort of feeds into the rhetoric that Premier Doug Ford has used to push this bail issue. And so I was just wondering, what is the solution here in the short term? Obviously, you guys are pushing for more social programs and to try to fix the causes of all of this violence, but are provinces just to accept that stabbings like this from people on bail are just going to happen, and there's nothing that can be done in the short term to tamp down on them? I don't know who to direct that to. Anybody who feels that they can best answer it would be great.
Perhaps we'll start things off with Catherine.
Yes, sure. While I'm not particularly familiar with that case, it does speak to some concerns generally about the effectiveness of the overall bail system. And I think it's important for those who are in active violent crime cycles that they not hurt other people. But at the same time, the way that the bail system is actually working is that it's incarcerating far too many people unnecessarily, whose risks could easily be managed in the public. And I think that's why we need an important evidence-based review of what is going on there. And if you just look at the body count of people who are dying, it is overwhelmingly people who are not given bail, who are dying behind bars, over those who may have caused deaths while being released on bail. So I think it's important to look at where harm is actually being done in order to have a comprehensive and good approach. But I don't think any of us would want to see people being victimized or hurt. But we need a good approach to dealing with that.
Follow-up?
Is there, I mean, that's a fair point, but it's not a politically palpable one that politicians can sell to people. What is a solution here that won't make things worse, but can be sold to the public to make them feel safer?
You raise a very interesting point, Alan, and that is should people be changing the laws based on public perception, which is not rooted in evidence? Or is there a public education function that needs to occur to explain what is going on here? I wish I knew more about the facts of the particular case that you're raising, but I have no idea what that person's original offense was and what kind of risk pattern they offered. I will say that predicting future violence is more of an art than a science. So it's not necessarily easy to do, but certainly more needs to go into it. And we need also to consider the risk that's being posed to people who are being asked to remain in custody during their pretrial period.
Thank you. We're now going to go to JP Nadeau at CBC Radio-Canada. JP.
Good morning, everyone. Thank you, by the way, for holding such a press conference. I think it's important. I do believe there's a lack of public understanding, as I have covered the courts for the past many years. But do you think that this new bill was put forward just because of the public outrage after the death of OPP Constable Piaccella in Alderman, North York, I think, County last December, just after Christmas? I don't know if you remember, but he was killed by two individuals, a man and a woman, allegedly. And those two were on bail, free. And so some people and the Premier of Ontario said the constable would be alive today if those two individuals had been behind bars and bail denied. So what do we do for those unusual cases? I think it's more the exception than the rule, but what do you do for those very hard cases where someone, especially a constable, is losing his life because of some flaws in the bail system?
Emilie Coyle, if you might want to direct the question to the appropriate person or to yourself.
Yes. I mean, I think I might call on some of my colleagues, but I just wanted to perhaps put this out there as a introductory piece to respond to what you asked, JP. And I thank you for contextualizing your question by letting us know that you've done this for a long time and you've seen the failures in our justice system when it comes to bail. So I think that that's really important that we focus on that. Let's be real. Everything that we do when we are working in this field is focusing on some extenuating or some one-off or unique circumstances when 99% of the work that should be done could be done focusing on people who have very high needs and little risk to the public. And if we focus beforehand, before that harm is perpetuated in our communities, that would be probably something that all of us could agree would be of value. Certainly, as I said in my opening and my concluding remarks, we are organizations that are concerned with harm first and foremost. And the harm that we see is also harm that happens when people are jailed and people are dying in our jails. And that harm is something that is not often talked about. And we fear that the people who are in our jails are not seen as worthy of protection. And so we wanted to bring that forward as part of this conversation, because we believe as organizations and at the Canadian Association of Elizabeth Fry Societies that everybody should be protected and everybody deserves that kind of protection from state violence as well. So I may leave it to Amanda Butler. Did you want to say something in response to that?
We'll go to Amanda and then Shakir, I think, would like to chime in as well.
Great. Thanks, Emilie. I also really appreciate, JP, that you drew attention to these cases being exceptional cases and not the rule. And I think what I would encourage people to think about is alternatives. So when we say things like, if they had been in prison, this wouldn't have happened, But what if they had been in community with proper resources and housing and access to psychiatrists and access to community? Then not only would we potentially be able to reduce acts of violence and harm, but we would also be able to reduce the harms caused by the criminal justice system. And so our default is, incapacitating somebody in custody. But I've spoken to practitioners and psychiatrists, for example, in the community courts and mental health courts, who say, there's so much I would be able to do if I just knew I could keep somebody housed. They don't actually need to be in custody. Part of the reason why I can't treat them is because I can't find them. So that's just the one thing that I want to add, is that if we actually invested in the alternatives, then we could envision a world in which we would be able to reduce these incidents, but also improve the lives of people who are in custody and their families who suffer, grave consequences as a result of people cycling through custodial sentences. I'll pass it on.
Shakir, you have the floor.
Thank you, Amanda. And I want to underscore why it is that we are focused on these types of community interventions and supports to address these types of exceptional cases. It's because for every exceptional case, there are the thousands and thousands of cases you don't hear about. The cases where somebody was out on bail, did not commit any act of violence, and therefore speaks to how our bail system can function effectively. If we were to deny bail to everybody, as some politicians are proposing, what that means is thousands of people who are innocent and never found guilty of what they are charged with are instead going to spend time in jail in conditions, as we have heard, that are deplorable. So we do think we have to address those exceptional cases, but we are offering, as my colleagues have noted, what the actual evidence-based solutions to those cases are in a way that ensures that the constitutional rights of Canadians are upheld and that those who are innocent are not put in prison before they have their day in court.
Thank you, Shakir. JP, do you have a follow-up, une question supplémentaire?
Yes, maybe. I was appalled by your numbers, by the way, comparing to the US and the UK. I'm very surprised. Isn't that also the problem in this country, to access to justice, that you wait too long? And as a reporter, you cannot understand how fed up we are to go to court, and there's a postponement date again and again. And I've been tracing people who are still in jail and waiting for their trial. And it seems like the Jordan decision from the Supreme Court hasn't changed anything, because you're supposed now to get a trial within 18 months before the lower courts and 36 months before the higher courts. Is that a problem? If we had less people waiting in jail for their trials, the justice would be more accessible.
May I?
Yeah, Catherine?
I think that's an excellent point, JP. There's a real delay in getting a person's day in court. And that leads to people being pretrial, which is a very anxiety-producing state of being, as well as disruptive of your lifestyle for far too long. And as Rachel points out, if you're on pretrial conditions for 3 years, you're going to have a technical breach at some point. It's very difficult to observe, very onerous conditions for long periods of time. So the speed with which the criminal justice system is operating is way too slow. I think when you point to the other international figures, I think the speed with which things progress really is a problem. And they need to look at the US, who has rocket dockets and all kinds of things that move things through at a much faster pace, and figure out what's going on here. Why is the Canadian system of justice so slow? Is it the absence of legal aid? Is there somehow defense counsel agreeing to delay after delay for no apparent reason? We need to figure it out, and we need to move it ahead if we're going to have any form of justice. And it would improve the numbers around pretrial detention and release. So it's a big issue, and I'm glad you've identified it. Thank you.
Thank you, Catherine. Was there any
I also just wanted to
Yep.
harken back to the remarks that Danette made from the Black Legal Action Center, because what she really highlighted was the role that racism also plays in the large numbers of people that come before the courts. And so, we have a system that is in crisis, and because of that system that is in crisis and the racism that people, are subject to, and all of the numbers of people that are going before the courts, it prevents us from being able to responsibly address these very rare, extreme cases that both of you referenced at the beginning. So.
Thank you. We're now going to go to Catherine Krakowski. Pardon me if I've mispronounced your name, with Alberta Today. Catherine?
Thanks very much. And no, that's a perfect pronunciation. I'm wondering what has the concept of reverse onus and bail been legally challenged before in Canada? Like, I'm wondering if there's been constitutional challenges before. What's the legal precedent for that?
Thank you.
I'm happy to jump in there. So there have been legal challenges before to reverse onus provisions, and while they are constitutional as a concept, they are not unlimited. There has to be a way for that reverse onus to be properly tailored to the particular offense that it concerns. And there have been serious concerns expressed by our organizations, by lawyers, that these reverse onus provisions are too broad because they cover situations like a discharge, which, as I mentioned, is a disposition that is only given out in very narrow circumstances when it's in the public interest to do so, and could cover offenses that are of a very low danger to the public, like licensing offenses, as I mentioned, that these reverse onus provisions are overbroad, and it is not justified that a person has to prove why they should be released before a trial in these situations.
Thank you. Follow up, Catherine?
Yeah, so I guess, is there a potential that this could, because this is overly broad, it could be opened up to new legal challenges and this bill could be overturned, I guess?
I'd say there's definitely a potential for that, to answer your question.
Thank you. We are now going to go to, I have Palak Mangat from Parliament Today. Go ahead.
Hi, thanks for taking our questions. I think this one may be best for Catherine Latimer or Emilie Coyle. And it's a similar question around capacity as I think JP was capturing. A couple of you spoke about the rate of people waiting trial. And I think that number was also cited by the minister when he tabled the bill around that number is 70% across the federal system. But the minister really couldn't speak to how the changes in the bill could put I guess we could say a further squeeze on existing resources. So can you speak to that possibility or concern here around capacity and what tangible impact the bill, if passed as currently written, it could have?
I'll just say, so the 70% was the provincial jails, just to be clear. And I will let you answer, Catherine, but I want to answer by saying this. What the tabling of Bill C-48 did, and why we were so concerned about it, is because it played into a narrative that something was wrong with our bail system and that it wasn't restrictive enough. That's what Bill C-48 sort of indicated in the tabling. And what we have been calling attention to for years is that, in fact, the issue with the bail system is not that it is too restrictive, or not restrictive enough, but that it is too restrictive. And so, whether or not Bill C-48 is going to have a real tangible effect on, practical effect on the courts or not, what it has done is it has played into the fear mongering that is occurring across the country, and a narrative that isn't based on real data. So I'll leave it to you, Catherine.
Well, I agree with everything you said, Emilie. I think it is a challenge. I think the numbers that I was giving that looked at international comparison includes the federal prison population with the provincial one. So that's the overall amount is about 37-38% of all prisoners in Canada are held pre-trial, which again, I say is an international embarrassment. The capacity issues, and I think others have spoken to the capacity issues, they're already crowded they're all held. All the pretrial people are being held in provincial institutions. Provincial institutions are very ugly places to be. There's no programming, there's no recreation, there's an emphasis on security, there's too many lockdowns, they're dirty. All of the federal prisoners that we talk to say the buckets, which is how they describe remand centers, are far worse than sentence custody. So the capacity for detaining people in humane conditions in pretrial is already awful and really inhumane and an embarrassment to the first world country like Canada. So anything that adds to that is only going to compound an already serious problem. So the capacity doesn't exist. But thank you very much for your question.
Thanks. And just as a follow-up, I think, Emilie, you may have answered it when you were talking about that the bill plays into a certain narrative. My follow-up question was going to be, so far we've seen a lot of the premiers and the federal government framing the bill as a way to address violent repeat offenders. I did hear you say that it's kind of more of a Band-Aid solution. So I just wanted to ask you about maybe the motivation of some premiers in supporting this, because from what we gather, the Justice Minister is looking to have unanimous consent for it.
I mean, what I think is happening is that people are concerned about public safety. That is always going to be a driver. And we are also concerned with public safety. We all are. But the real conversation here is around rights, is around who is being put in our jails and why. And, you know, signing on to a letter that purports to deal with issues of harm in our community by having more restrictive bail conditions is not going to get us to where we want to go. And we share the desire to have a community that is free from harm. And so our desire in having this press conference today is to shift the narrative to really bring into focus what needs to happen in our communities. You know, and I said in my concluding remarks, we are happy that they're focusing on housing and healthcare, and these are really, really important pieces of how we keep each other safe and free from harm in our communities.
Thank you, Emilie. I'm going to do one last call for questions before we conclude the press conference. Just a reminder that the letter to the Council of the Federation, as well as the press release, which will include a link to the recording of this press conference, will be made available to participants and to members of the media shortly thereafter the press conference. Okay, seeing as how there are no further questions, this will conclude today's press conference. Merci beaucoup à toutes et à tous d'avoir été parmi nous aujourd'hui. Ceci va conclure notre point de presse. S'il vous plaît, guettez vos courriels pour un communiqué de presse ainsi que l'enregistrement du point de presse aujourd'hui. Thank you very much.